Hi, it's Haji from Haji Amos PLC. Today we are going to be talking about trademarks. The question of the day is I received a notice of allowance for my trademark, but now I'm looking on the USPTO's website and I see that my mark is dead. Well, there are several steps that have to be taken after you have a trademark allowed that most lay people forget about. It does make common sense that if the PTO tells you, "Hey, we allowed your trademark," that you think you got the trademark, and you start using the R with a circle around it, and you think you're good to go. But that's not the case. There are lots of steps that come after that. So as soon as a trademark is allowed, there is what we call a period of opposition. The USPTO will publish a trademark in what used to actually be a book. It's now just a database that you can search online. It's called the Official Gazette. It's published once a week. Used to be on Tuesdays. I think it's still on Tuesdays. Not sure about what day it publishes, but your trademark will be published along with, I don't know, 20,000 other trademarks for what they call opposition. The opposition period is a 30-day window of publication which allows anyone who believes that they could be harmed by registration of your trademark to oppose your trademark. Essentially, what that means is that they can file a notice of opposition and they can put the registration on hold. Trademark opposition is a very long and lengthy process. The first step is, again, filing that notice of opposition. What happens after that is essentially litigation. The notice of opposition is essentially a federal complaint for potential trademark infringement. What comes after that will be a discovery conference, discovery phase, motions to compel, motions for summary judgment. Any motion or objection that can be filed or asserted at trial can be asserted during the opposition period. And there is a trial. The trial is a bit different than a traditional trial. An opposition trial is on paper, so trial briefs are filed. There is no need for a hearing, so you don't all have to go show up in the federal court and sit there all day and present your case orally. There are depositions that can be taken. The depositions can be written or they can be in person. So there are some aspects of a traditional trial that are maintained. The only difference I'd say is that you don't actually physically need to go in for a trial inside of a courtroom. Now, if you go through the opposition period and no one files an opposition, then a lot of people say, then they think they're good to go. Well, no, there's another step. You actually need to file a statement of use. So trademarks are not based on registration, they're based on use. So if you filed your registration and you did not assert use at that time, you'll need to assert use before your trademark actually registers. So you will need to file a statement of use, which is an affidavit that says, I'm using the mark on this class of goods in this way, and here's a handy dandy photo or exhibit or specimen that shows use of the mark in relation to the category of goods that you filed. Now, the specimen must match the application. So it's really important that you show use that is consistent with how you described it in the application, otherwise it'll be rejected. If your specimen is accepted, then at that point, your application will register. It takes about 3 to 6 weeks in order for them to finalize the registration, and then another 3 to 6 weeks in order for them to send out the registration form. But as soon as that registration is final, you can look on the USPTO's website. There's a trademark database, and you can see all the documents. So before you actually get it, you'll be able to download a copy of it, and you'll be able to start using that registration. So again, if you found this helpful, please subscribe. And there's lots more information on my website. It's ahajiamos.com. That's AHAJIAMOS.com.